It appears that the Trump administration is trying to rendition and deport a legal permanent resident because of First Amendment protected speech and protesting. I guess we've now reached the chapter of the authoritarian playbook that involves disappearing political dissidents. The Trump administration, seemingly annoyed by protests against Israel that spread across campuses since October 7th, has loudly threatened to crack down on the universities and their students, even to the point of deporting people on student visas who engage in acts of protest. And protesting, need I remind you, is one of the most protected forms of speech under the First Amendment. And yet this week, the Trump administration seemingly made good on that threat when ICE arrested Palestinian activist and former Columbia grad student Mahmoud Khalil and declared that his student visa was being revoked. But the administration failed to notice or didn't care that Mr. Khalil holds a green card. Yes, that's right. He's actually a legal permanent resident. No matter though, they arrested him anyway and then sent him on a seemingly wild voyage to potentially a legal jurisdiction that will be more friendly to the administration's deportation goals. The administration refused to explain why Mr. Khalil was being held, and for 5 days denied Mr. Khalil his right to talk with his attorney. This turn of events has sparked protests and rang every alarm bell that there is for students, free speech advocates, and everyone who cares about basic civil liberties. And at the time that we're filming this video, Mr. Khalil is still in custody in Louisiana pending deportation. So the question on everyone's mind is, can the government really just revoke permanent residency and deport someone for First Amendment protected speech? Now the situation is fluid, we don't know all the facts, but here's what we know. According to his court filings, on the evening of March 8th, Mahmoud Khalil arrived at his apartment building with his pregnant wife. As they entered the Columbia University-owned student housing building, they were approached by 4 plainclothes officers who asked Mr. Khalil to confirm his identity. When he did so, they identified themselves as being with the Department of Homeland Security and said they were there to take him into custody. They also threatened to arrest his 8 months pregnant wife if she continued to remain at the scene. Mr. Khalil was able to make a call to his attorney, Amy Greer, who asked one of the ICE agents if they had a warrant. The agent claimed they did and informed Ms. Greer that the U.S. Department of State was revoking Mr. Khalil's student visa. Ms. Greer pointed out that Mr. Khalil isn't on a student visa. He's a lawful permanent resident with a green card. Mr. Khalil's wife provided the paperwork to confirm it, and the ICE agent seemed confused. They checked in with someone on the phone, then replied that the Department of State was revoking Mr. Khalil's green card too. ICE informed Ms. Greer that they would be detaining Mr. Khalil in Manhattan. When Mr. Khalil's wife asked the ICE agents for their names, contact information, and how to reach them, they refused to reply. They would not even provide the grounds for Mr. Khalil's detention. While Mr. Khalil was being held in Manhattan, Ms. Greer filed a habeas corpus petition challenging the legality of Mr. Khalil's detention on the grounds that it was a violation of the First and Fifth Amendments and several other laws. Ms. Greer argued that the government was retaliating against Mr. Mahmoud for his protected First Amendment activities, specifically his role in the pro-Palestinian protests at Columbia University. Now, in the wake of the October 7th attack on Israel, Mahmoud Khalil became active in the Columbia University pro-Palestine movement. According to news reports, he did not participate in the encampments or building takeover, but did represent the voice of the protesters in conversations between the student protesters and the university's leadership. Mr. Khalil has said in earlier interviews that his engagement with the pro-Palestinian protests was partly inspired by his own family's history. He was born as a Palestinian refugee in Syria after his family was expelled from Palestine. In December of 2022, he arrived in the United States on a student visa to work on a master's degree at Columbia University. Later, he married a U.S. citizen and became a green card holding permanent resident. Now, a legal permanent resident, or LPR, is a foreign national granted permission to live and work in the United States. Generally, LPRs can live and work in America indefinitely as long as they don't commit any deportable offenses. Deportable offenses generally include committing crimes, immigration fraud, or engaging in actions that threaten national security. In recent months, Columbia University, under threats from Congress and the Trump administration, that we'll discuss later, launched an investigation of Mr. Khalil, claiming that he had helped organize an unauthorized protest and had played a substantial role in the circulation of social media posts that were anti-Zionist and discriminatory. There's not that much information about what Mr. Khalil said and did during the Columbia University protest, but he did act as the lead negotiator between the university and student groups who were pressuring the administration to divest from Israel. In an interview with CNN in April of 2024, he called for Columbia to divest from companies who supported Israel, and he participated in a sit-in at Barnard College the week before his arrest. So why this one guy out of tens of thousands of protesters? Well, Mr. Khalil had previously given media interviews about the protests and had been visible without a mask during them. But probably more importantly, in the weeks leading up to his arrest, Mr. Khalil became the target of pro-Israel activists online who accused him of supporting Hamas, encouraging students to join a, quote, pro-terror group on campus and being part of a conspiracy to distribute terrorist propaganda. And then a Twitter user demanded that he be deported and tagged Secretary of State Marco Rubio. Now, it doesn't really matter whether we agree or disagree with anything that Mr. Khalil said or is accused of saying. The First Amendment prohibits the government from censoring speech based on the viewpoint it expresses, and people generally have a right to say whatever they want, including speech that many people would find offensive and abhorrent. Just ask the Westboro Baptist Church. You might remember in 2011, the Supreme Court ruled that the church's protests at military funerals, which included offensive and hateful speech such as "God hates gays" and "Thank God for dead soldiers," was still protected speech. The court emphasized that even deeply offensive speech on public issues in public spaces is shielded from government restriction. Now, the Trump administration publicly claimed that Mr. Khalil's arrest is sanctioned by its executive order on additional measures to combat anti-Semitism. In this order, the administration professed that it has, quote, fought and will continue to fight anti-Semitism in the United States and around the world. The White House went on to specifically threaten action against universities, stating that the Secretary of State, Secretary of Education, and Secretary of Homeland Security will make recommendations for, quote, familiarizing institutions of higher education with a list of supposedly illegal anti-Semitic student activities. Universities were then supposed to monitor student activities, report prohibited activities by non-US citizen students, and ensure that those reports led to deportations. In a related fact sheet, the White House proclaimed that it would deport Hamas sympathizers and revoke student visas, threatening to, quote, we will find you and we will deport you. And where Mr. Khalil is concerned, the government has been very clear that it's attacking the content of his speech. The White House posted on Twitter about Mr. Khalil's arrest saying, quote, Shalom Mahmoud. ICE proudly apprehended and detained Mahmoud Khalil, a radical foreign pro-Hamas student on the campus of Columbia University. This is the first arrest of many to come. And DHS spokesperson Tricia McLaughlin wrote that Mr. Khalil was arrested in keeping with the executive order on anti-Semitism because he, quote, led activities aligned to Hamas, which is such a tell in this case. You know that if they had actual evidence apart from just speech, they absolutely would have included it in that press release. But DHS has not provided any information indicating that Khalil provided physical support to the terrorist group. And Secretary of State Rubio posted a story about Mr. Khalil's arrest, proclaiming that the administration would be revoking the visas and green cards of Hamas supporters so they can be deported. Trump himself posted citing his executive order and stating that his administration will apprehend and deport what he calls terrorist sympathizers on campus, and that he expects every one of America's colleges to comply with the administration's stated goal to do this. Trump accused Mr. Khalil and other Columbia students of being, quote, pro-terrorist, anti-Semitic, and anti-American. On March 13th, students, including Mr. Khalil and advocates with the Council on American Islamic Relations, struck back against Congress's demands and Columbia's complicitness, filing a lawsuit to stop the university from sharing any more student information with Congress. In their lawsuit, the students argued that sharing student information with Congress would be a violation of the First Amendment, student privacy laws, and the university's contractual obligations to its students. The plaintiffs urged the court to issue an injunction against further information sharing, stating, quote, this nation is seeing a new wave of repression by this Congress and this new administration that pose a great threat to the First Amendment, akin to the threat that McCarthyism and the broad overreach of the role of the House Un-American Activities Committee posed 50 years ago. That threat became even more real when the Trump administration attempted to familiarize Columbia University with its obligations under Trump's executive order on combating anti-Semitism by canceling $400 million in grants to the university, ostensibly because the school had failed to quell anti-Semitism on campus. And then the Trump Department of Education, led by the highly qualified educator Linda McMahon, threatened to lay the smackdown on 60 universities for supposedly anti-Semitism claims.
Thank you.
So it seems that the Trump administration is penalizing both students and universities for the content of their speech. Now, if the government is punishing you for First Amendment protected speech, you're gonna want a great lawyer, and my law firm, the Eagle Team, can help. If you've gotten in a car crash, if you've suffered a data breach, especially if you got a data breach letter saying your information might have been leaked, or are dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. So you might be wondering at this point if the government can just spirit someone thousands of miles away from their home to revoke their green card. And like many things this administration has gotten up to in its first 2 months, the answer is no, that's probably not legal, but the Trump administration is going to try and do it anyway. Now, there are many different ways to obtain a green card, including winning the visa lottery, having a US citizen parent or close family member sponsor you, or marrying a US citizen. And generally, green card holders are permitted to stay in the US permanently, but there are some circumstances where they can be removed. Now, the government has yet to file legal documents identifying the grounds for Khalil's deportation, but we know they're probably not relying on the terrorism-related provisions. Instead, Secretary Rubio's comments suggest the government will rely on a more obscure and vague provision in the Immigration and Nationality Act, 8 U.S.C. 1227. Now that statute states, quote, an alien whose presence or activities in the United States the Secretary of State has reasonable ground to believe would have potentially serious adverse foreign policy consequences for the United States is deportable. Now, under that same provision, though, an immigrant cannot be excluded based on beliefs, statements, or associations that would be lawful within the United States unless the Secretary of State personally determines that the immigrant's admission would, quote, compromise a compelling United States foreign policy interest. Now, Secretary Rubio seems to have made that determination. Under what due process, we have no idea, and of which we are very skeptical. And that would seem to give the government a lawful, though potentially not constitutional basis for Khalil's removal. The government may try to simply characterize Mr. Khalil's behavior as criminal. The government hasn't identified any particular behavior as criminal, and obviously speech alone is not criminal under almost all circumstances. But under the INA, an alien is deportable if they have been convicted of a crime involving moral turpitude or a felony. However, under 8 U.S.C. section 1182, Rubio is required to notify Congress about his determination. We don't know if Rubio has done this yet, and based on his comments, it seems that Rubio might be compiling a list of green card holders to give to Congress. But Khalil is likely to challenge the constitutionality of section 1227. Others have challenged this provision for being constitutionally overbroad. In one of the few cases dealing with the constitutionality of this provision, a case called Massou versus Reno, the judge, and I kid you not, the judge was Marianne Trump Berry, President Trump's older sister. The judge issued a blistering rebuke of the provision, stating that, quote, the statute represents a breathtaking departure both from well-established legal precedent, which commands deportation based on adjudications of defined impermissible conduct by the alien in the United States, and from well-established precedent with respect to extradition, which commands extradition based on adjudications of probable cause to believe that the alien has engaged in defined impermissible conduct elsewhere. Massou was a Mexican national who legally resided in the United States, and Mexico sought to extradite him for convoluted reasons that Judge Trump Berry described as truly Kafkaesque. She addressed the central question, which is whether the language of section 1227 actually contains a recognizable legal standard. Could a green card holder look at the statute and figure out what conduct is deportable? Because all it says is the Secretary of State must conclude that the immigrant's presence would have, quote, potentially serious adverse foreign policy consequences for the United States. So Trump Judge Berry wrote, quote, while there may be a common understanding in a definitional sense of what foreign policy is, no one outside the Department of State and perhaps the president ever knows what our nation's frequent covert foreign policy is at any given time. Thus, there is no conceivable way that an alien could know ex ante how to conform his or her activities to the requirements of the law. Of course, it is even less likely that an alien could know that his or her mere presence here would or could cause adverse foreign policy consequences when our foreign policy is unpublished, ever-changing, and often highly confidential. And the judge held that that statute is unconstitutionally vague and that it violated the Fifth Amendment right to due process. And as the judge ruled, all Massou did was criticize the Mexican government, which had no conceivable impact on U.S. foreign policy. However, the government appealed, claiming that the plaintiff had failed to exhaust his administrative remedies. The appeals court agreed, and then in an opinion written by, I kid you not, then Judge Samuel Alito, stated that it would not adjudicate the constitutional merits because Mr. Massou had to first go through the administrative process. And now the constitutionality of this provision has not been considered since. So it's likely that Khalil could challenge the statute on free speech grounds. The government is arguably retaliating against him by arresting and potentially deporting him in response to his participation in protected speech. Generally, the First Amendment does not distinguish between citizens and non-citizens, meaning that the government cannot punish a non-citizen for speech it could not punish a citizen for. However, courts have taken a more nuanced approach when it comes to the government's ability to deport non-citizens based on their political affiliation in speech. In the McCarthy-era case of Harisiades versus Shaughnessy, the Supreme Court upheld the deportation of several immigrants who were Communist Party members, reasoning that endorsing communism was inherently an endorsement of violent revolution. The court drew a legal distinction between advocating change through lawful democratic means and advocating change through force, concluding that the Communist Party membership necessarily involved the latter. Though I'm skeptical that that reasoning would be upheld under current jurisprudence. In contrast, the 1945 case of Bridges versus Wixon took a more protective stance, affirming that the First Amendment does not include exceptions for deportation laws, thereby defending the free speech rights of resident aliens. In that case, Harry Bridges was an Australian-born labor leader accused of being a communist. The government argued that his alleged communism ties made him ineligible to remain in the US. The court said that the mere association with a political ideology without evidence of unlawful action was not grounds for removal. The decision emphasized the importance of protecting free speech and political expression, even for non-citizens. But even if the administration wants to deport Mr. Khalil under this provision, and even if it can cite a compelling foreign policy interest, and even if it can overcome legitimate concerns about constitutional problems of the provision, Mr. Khalil is still entitled to due process under the Immigration and Nationality Act. He must receive notice regarding the legal and factual grounds for his removal, and must be given a hearing before an immigration court. In these proceedings, Mr. Khalil will be entitled to an attorney, must be permitted to see and refute the evidence against him, and must be allowed to cross-examine witnesses and make his case. The government will then have to prove by clear and convincing evidence that there are legal grounds to deport him. Though generally it is permissible for the government to detain an immigrant while their removal is pending. Now, Mr. Khalil's attorney, Amy Greer, immediately petitioned for a writ of habeas corpus in the Southern District of New York, where Mr. Khalil was being held. A habeas petition is a procedure under which the federal court can review the legality of a person's incarceration. It means literally you have to produce the body. And it allows a court to order the law enforcement authorities bring the incarcerated person before the court and explain the basis for their detention. This was the framers' main tool to prevent being arrested without any explanation and being held without trial or formal charges being filed. So in his motion for a writ of habeas corpus, Mr. Khalil, the plaintiff, argued that his detention is unlawful because it's a violation of his First and Fifth Amendments. Because it's a violation of his First and Fifth Amendment rights, the Immigration and Nationality Act, and the Administrative Procedure Act. The motion focused primarily on his First Amendment claims, arguing that Mr. Khalil was being detained and potentially deported in retaliation for his First Amendment protected speech regarding the conflict between Israel and Palestine. He argued that there is, quote, a substantial causal connection between Mr. Khalil's protected speech and respondents' adverse actions and threats. Plaintiff argued that because of these violations, he's entitled to relief from that court. Specifically, the plaintiff argued that the Southern District of New York should assume jurisdiction over this matter where he resides and apparently where he was when the motion for habeas corpus was filed before he was effectively renditioned to Louisiana. And he argues that the court should declare that the government's actions violated the First Amendment and the Due Process Clause of the Fifth Amendment, order the release of Mr. Khalil under reasonable supervision, and enjoin the government from transferring Mr. Khalil out of the jurisdiction while the proceedings are pending. Seemingly in response to Mr. Khalil's request that the court enjoin the government from transferring him out of the jurisdiction, and miraculously, Mr. Khalil's lawyer filed that motion at about 3 o'clock in the morning the night that he was arrested. Now, in response to Mr. Khalil's request that the court enjoin the government from transferring him out of the jurisdiction, the Trump administration sent Mr. Khalil 1,000 miles away to Louisiana, effectively separating him from his 8 months pregnant wife, his attorney, and the Southern District of New York. Mr. Khalil's attorney said that when she called the Louisiana office to try to arrange a telephonic meeting with her client, the earliest date she was offered was 10 days out. Louisiana also appears to be the government's favorite dumping ground for immigrants going through removal proceedings. In February, the Department of Defense moved migrants waiting for removal from Guantanamo Bay to the same processing facility in Louisiana, which was why Mr. Khalil's attorney promptly filed a motion to compel his return to the Southern District of New York under the All Writs Act. So far, Judge Jesse Furman is allowing the case to move forward. He hasn't yet granted the plaintiff's request that Mr. Khalil be returned to New York, but he did order the government not to deport Mr. Khalil while the case is being considered. In a joint letter filed on March 11th, the parties asked for further briefing on the issue. Unsurprisingly, the government is using Mr. Khalil's detainment in New Jersey and then Louisiana to destroy the Southern District of New York court's ability to hear the case, and ask the court not to rule on returning Mr. Khalil to New York until the court has decided about the jurisdiction and venue questions. The court agreed to allow the government to file its motion to transfer or dismiss for improper venue before the court adjudicates the motion for writ of habeas corpus and the motion to return Mr. Khalil to New York under the All Writs Act. And on March 12th, the government filed its motion to dismiss or to transfer the case, arguing that by the time that Mr. Khalil's attorney filed the habeas motion on his behalf, he was already in New Jersey. So therefore, the Southern District of New York has no jurisdiction over the case because a habeas petitioner has to file the petition in the district in which he is confined. Thus, the government argued that the case ought to be either transferred to the Western District of Louisiana, where rights seem to be a little more discretionary, or dismissed entirely. Though it's worth pointing out that the government doesn't dispute in its filing that Mr. Khalil's attorney had good reason to believe that he was still being held in New York when she filed the petition on his behalf. Indeed, the government concedes that it was ICE's own statements and own tracking website that indicated he was still being held in New York at the time. Meanwhile, Mr. Khalil is still being detained in Louisiana. Mr. Khalil's attorneys have now filed an amended petition for habeas corpus on his behalf, expounding on their claims of First and Fifth Amendment violations and violations of the Administrative Procedure Act's prohibition on arbitrary and capricious government actions. Plaintiff's amended petition lays out a comprehensive list of Trump administration statements that illustrate a clear intent to chill legitimate free speech with a policy of deportation under the obscure and vague foreign policy provision of the Immigration and Nationality Act. Likely because of the court's prior order, Mr. Khalil's attorney was finally able to reach him to discuss the deplorable conditions of his detainment, which, as described in plaintiff's filings, include being shackled as he was whisked across jurisdictions, being denied necessary daily doctor-prescribed medication, and being housed in a, quote, bunker without a pillow or blanket. It also appears that Mr. Khalil might have been taken back to New York after he was taken to New Jersey, which would negate a lot of the jurisdiction arguments, but we'll see. But in light of the unlawfulness and harsh conditions of Mr. Khalil's detention, his attorneys have asked for him to be released on bail pending the adjudication of his immigration status. The judge will likely rule on the parties' motions next week. And as his wife has pointed out in her public statements, their first child is due in April, a birth he's likely to miss unless the court decides to intervene on his behalf. And one of the many deeply troubling things about Khalil's story is how much the internet played a role in punishing Khalil's speech. It seems that online vigilantes hunted him until their social media posts caught the attention of Secretary of State Marco Rubio. But it is darkly fascinating to see how the media has covered all of this. When ICE arrested Mr. Khalil, 374 news sources covered it, with 30% of the coverage coming from the left, 45% from the center, and only 25% from the right. And when you examine the headlines, you see some very different framings emerge that shape how readers interpret and understand the events that are unfolding. On the right, the most common theme is to emphasize that Khalil and his protesters are pro-Palestine or even pro-Hamas, as we've seen here. On the left, headlines stress that Khalil is a green card holder, which draws attention to the thorny legal questions that we've discussed here. And then from the center, nearly every headline uses the word arrests, which speaks to an implied accusation of an alleged crime that may have occurred, or may not have occurred. But the headlines you read first have immense power to shape how you understand the news. And that's why I like to see the news from as many angles as I can, which I can with the help of today's sponsor, Ground News. Ground News is a website and app developed by a former NASA engineer on a mission to give readers an easy, data-driven, objective way to read the news. And right now they're offering LegalEagle viewers 40% off their unlimited access Vantage subscription. You can scan the QR code or use the link in the description to get a discount for a limited time. But Ground News gathers related articles from around the world and across the political spectrum, so you can see the bias and compare coverage. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the source's reporting, all backed by ratings from 3 independent news monitoring organizations. One of my favorite parts is their bias comparison feature, which highlights specific differences in reporting across the political spectrum. This can be especially helpful when reading stories from sources you've never heard of, where there's no telling who owns it or what agenda they might have. I also love the blind spot feature, which shows you stories that are underreported by either side of the political spectrum, like the related story of Columbia University refusing to comply with the White House's orders to identify students who are sympathetic to Hamas. This story was entirely ignored by the left, with 75% of the sources coming from the right and only 25% coming from the center. This type of analysis helps explain why we often talk past each other and why some people seem hyper-focused on what seems like nonsense or fake news. But all this is why Ground News is my favorite way to get the news. And as a legal eaglet, you can save 40% off the Ground News Vantage subscription by scanning the code on screen or clicking on the link down below. This subscription gives you unlimited access to every feature, including the Bias Insight tool and blind spot feed. And by subscribing, you'll support an independent news platform working to make the media landscape more transparent. So click on the link below or scan the code today. And after that, click on this link over here for more Legal Eagle, or I'll see you in court.